All right. And has Child Protective Services been involved with her?
Yes, Your Honor.
And what is the results of that?
Um, they are recommending upon her release to put her on in a safety plan, so she can work into getting a better relationship situation with the child. Uh, I asked my client about arrangements for the child. Angel's not going to be living at the household home that she's going to be going back to her husband, Christian, until the CPS plan is followed, and she can safely meet and visit with her and just reestablish that relationship.
So there is
A plea can sound routine until the court starts asking what happens after the defendant walks out. In this case, Judge Boyd is not only looking at the charge, she is looking at the home, the children, the CPS safety plan, and whether the conditions are strong enough to protect everyone involved. Watch how quickly a plea hearing turns into a full courtroom restriction.
Court is calling 2023 CR 9788 and 2026 CR 001199 State versus Elora Posada. Can I have parties announced?
Renee Munoz for Ms. Posada.
And are you Ms. Posada?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number, Ms. Posada, did you review? Just 1 second. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And the cause number ending in 99, did you review the waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes.
You have a right to have a grand jury hear the evidence in this case and decide on whether or not it's sufficient to render an indictment. Your attorney has a right to the passage of 2 days upon presentation of the information, and also 10 days to prepare for trial. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In that cause number, did you review the information with your attorney? Did you understand it? And in the other cause number, did you review the true bill of indictment with your attorney and did you understand it?
Yes.
Counsel, in each cause number, do you waive the readings?
Yes, Your Honor.
And state in each cause number, are you proceeding on the information in the indictment as presented?
Yes.
And the cause number ending in 9, you're charged with an injury to an elderly or disabled person. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court will find you guilty and sentence you, could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. And the cause number ending in 88, you're charged with the offense of credit card or debit card abuse. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. In that cause number, if I grant your application for deferred adjudication, if for any reason your deferred adjudication is revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? And each cause number, if you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
In each cause number, you have a right to jury, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers? I'm going to need you to speak up so the court. Counsel, in each cause number, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
And each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes.
In each cause number, if you're not a U.S. citizen, by entering into these pleas, you will be deported and denied naturalization. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it? And each cause number, the cases are to run concurrently. The state is taking in consideration 2026 PF 02856. This is run concurrent with DC 2023 CR 9788. And the cause number ending in 9, there's a $1,500 fine. And the cause number ending in 8, there's a $1,000 fine. There's to be restitution in cause number 8 of $131.75. Family violence, you're not allowed to own or possess any weapons or ammunition, and you're also not allowed to be designated as primary custodial parent. Did you understand? Did you understand that to be your plea in each of the cause numbers? Defense, is that the plea?
Yes, Your Honor.
State? In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, any such motion?
No, Judge.
Outside the agreement, in each cause number, the state is requesting that your community supervision be for a term of 5 years, 120 hours of community service, restitution, no contact with the complainant, and cause number ending in 8, anger management, MRT, TAP evaluation, and parenting classes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? And cause number 2026 CR 001199, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2023 CR 9788, how do you plead? Guilty, not guilty, or no contest?
No contest.
State in each of those cause number, any evidence to support the defendant's plea?
No objection.
Thank you. And state, have you had a chance to speak with the complainants in each of those causes?
And yes, okay.
All right, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that in each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right. So what is your relationship in cause number 9, the injury? What is your relationship to the person in that cause number?
I'm her mother.
And how old is she?
11 years old.
Okay. All right. So it appears that your client has some substance issues.
In speaking with her, Your Honor, she didn't notify me about any drug issues particularly. Ms. Posada, do you have any issues with substance?
No.
All right. So I'm basing that upon the police report. The police are stating that when they came out, you were intoxicated. Well, let me change that. They said that you were slurring your words.
Okay, she had been drinking that evening, and it appears, Your Honor, and that appears to be the basis of those observations. And in our estimation, there was a verbal altercation with her and Christian Pedrosa, her husband, and some alcohol may have been involved at that evening, but we don't believe it's a continuous thing or she has any significant issues with that, with that alcohol issue. Judge.
All right. And has Child Protective Services been involved with her?
Yes, Your Honor.
And what is the results of that?
They are recommending upon her release to put her on a safety plan, so she can work into getting a better relationship situation with the child. I asked my client about arrangements for the child. Angel's not going to be living at the household home that she's going to be going back to her husband, Christian. until the CPS plan is followed, and she can safely meet and visit with her and just reestablish that relationship.
So there is not any minors that are being allowed in the home at this time?
She has other children, that she has with Christian Pedrosa,
But are they in the
Yeah,
home,
they do.
minors?
they do reside at the home, Judge.
And Child Protective Services has nothing to say about that?
I haven't had any dealings with them. Did they tell you anything about that?
They just said, I was gonna be placed with the safety plan. With someone to be in the house with us at all times with the kids.
All right. And cause number 2023 CR 9788. Court is going to sentence you to $1,000 fine. That will be probated 5 years deferred adjudication. This is to run concurrent with 2026 CR 0119. There's to be regular reporting by Zoom or in person, regular random UAs. There's going to be a TAP evaluation. Out of custody, follow recommendations for TAP. There's going to be 120 hours community service restitution. There's to be 1 hour deducted for every completion of sober support meetings. There's going to be restitution to the complainant. And no contact with the complainant. And that restitution is in the amount of $131.75. There's going to be field visits 1 time per month until further notice. And there's to be no residing in households with minors. Counsel, that's until the safety plan is provided to probation.
Yes, Your Honor.
And probation, that's the safety plan from CPS. Probation, is there anything else in regards to that case? Thank you. Proof of employment within 45 days, no employment as a home health care provider or with minors. All right, next we're proceeding in 2026 CR 001199. And that cause number, there's an affirmative finding of family violence. There's to be no contact with the complainant. No harmful or injurious contact with regular reporting by Zoom or in person, regular random UAs, concurrent with 2023 CR 9788, taking consideration 2026 PF 02856, $1,500 fine that will be probated. No residing in households with minors. 200 hours of community service restitution, 1 hour deduction for every sober support meeting completed. There's going to be 20 hours deducted. And I'm ordering anger management. And there's going to be 100 hours deducted. And I'm ordering parenting classes. And there's to be field visits 1 time per month until further notice. And no residing in households with minors until the safety plan is presented. Probation, and proof of employment within 45 days, no employment as a home health care provider or with minors. Probation, is there anything else?
The term, Judge, for that one? The term for that one?
Oh, thank you.
That one does.
Yes, 5 years deferred adjudication. All right. Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
Thank you, Your Honor. Repeat it.
Sorry.
Okay, I got it. You ready?
Yes.
The next case is shorter, but the warning is direct. A defendant on deferred adjudication admits she failed to report, and the agreement gives Judge Boyd a clear path forward. But before the hearing ends, Boyd turns the sentence into something bigger than jail time. She focuses on what happens after release, and whether the defendant is willing to change before the system sees her again.
Court is calling 2025 CR 001273W State versus Ali Kelly. Can I have parties announced?
Renee Munoz on behalf of Ms. Kelly.
And are you Ms. Kelly?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Ali Joanna Kelly who was placed on deferred adjudication in 2025 CR 001273W for the offense of possession of controlled substance, penalty group 1, less than 1 gram, on February 5th, 2025 for a period of 2 years? Is that you?
Yes.
State?
Biased position number 4. In Dare County, Texas, the defendant Ali Joanna Kelly did then and there fail to report to the supervision officer as directed for the months of June and July 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
True.
No, do you understand that?
Oh, yes.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement grants the motion, revoke probation, enter an adjudication of guilt, and sentence to 138 days in the Bear County Jail under 1220.
Is that your agreement?
Yes, Your Honor.
Are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will grant the motion, find you guilty, sentence you to 138 days in the Bear County Jail under 1244, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
True.
Yes.
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question, on what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, here's the thing. If you do not get your life together and start making better decisions, you're either going to end up at the prison, at the Bear County Jail, or somebody's going to identify your body. What you're going to have to do is, when you're released, you need to go to a sober support meeting. If you can't find a place, you come back here. I'm still here. I'll pick up the phone and find somebody to help you. But you're going to have to stop this, okay?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
Your Honor, with regard to the request earlier about me assisting Mr. McCray Porter, I was speaking with them and it looks like it may be more so needed tomorrow, and I'm going to be out of town.
Okay, we'll find someone. All right, thank you. Thank you so much.
Across these two cases, Judge Boyd keeps returning to the same courtroom principle. Conditions only matter if they are built around the real risk. In the first case, that meant no contact, no minors in the household until a CPS safety plan was provided, restitution, parenting classes, anger management, and field visits. In the second case, it meant a revocation sentence and a direct warning about sober support after release. These were not random conditions. They were tied to children, family safety, reporting, sobriety, and whether the defendant would come back to court again. Comment which ruling you think carried more weight, and subscribe for more real Texas courtroom breakdowns. Every ruling has a reason. Court Beacon TV shows you both.